Parker.
On behalf of the Labour Party to support the first reading of the replacement foreshore and seabed legislation, and can I acknowledge Tariana Turia, who's just taken her seat. I want to make comments on three areas. Firstly, I want to talk about the history of the foreshore and seabed controversy. I want to then talk about the main changes that are brought about by the bill compared with the current Foreshore and Seabed Act. And then I want to end by, if I have time, talking about the need for a clear acknowledgement, which I think is necessary from the Maori Party, that they accept that it's proper that this be dealt with as a full and final settlement of the framework for determining customary interests in the foreshore and seabed, so that we as a nation can move forward without rancour. On the 19th of June 2003, the Court of Appeal announced its decision in Ngāti Apa, and it found that unextinguished Maori customary interests existed in the foreshore and seabed. We should recall that the case arose from unfair treatment of Ngāti Apa in relation to aquaculture in the Marlborough Sounds area, and the underlying issues in respect of that injustice have been cured in separate legislation. Aquaculture settlement legislation by the last Labour Party conferred rights upon Maori in respect of agriculture that settled the underlying injustice. The Court of Appeal decision in the Ngāti Apa case did not define what the threshold test was for customary interests, nor which of the rights were unextinguished. The Court of Appeal decision was a surprise to many. It overruled a line of cases that went back to the 1877 decision in W. Parata and the Bishop of Wellington, and that had been affirmed by the Court of Appeal itself in 1963 in the 90 Mile Beach case. Controversy soon erupted after the Ngāti Apa decision, and the reaction was not all about customary rights. There were two other significant factors which, in my opinion, were involved. The first was a septic political environment. There was divisive exaggeration and rhetoric, some of which from opposition parties in this politics, not the Greens, not ACT, who took a property rights position, and not New Zealand First. But from some National Party members, it's a matter of record that we should not shrink from recalling that Don Brash, Bill English and Jerry Brownlee all made repeated, inaccurate, exaggerated and divisive statements. They preyed upon the intolerance that lies so close to the surface of just about any country. They ramped up concerns in an irresponsible manner that pitted Maori against non-Maori and made settlement of these issues very difficult. Their task was made easier by some of the exaggerated statements that were coming from the other side of the debate. And in this I don't shrink from saying that Hone Haurawera was making assertions that were wrong, suggesting that the Ngāti Apa decision effectively gave ownership rights tantamount to freehold title rights to virtually the whole of the foreshore and seabed around New Zealand, and that was wrong too. There was a second factor in play, in my opinion, and that was that there was a widespread reaction against the Treaty of Waitangi being used as justification for policies that actually didn't need a treaty-based justification. At the time, there was social policy that was being advanced that was good, and just social policy to help people that needed a hand, and it didn't need the treaty-based justification. Now I know, and all of us in this House know, that the foreshore and seabed rights are not treaty-based, they're common law-based. But that technical distinction is not, that technical truth is lost upon many, especially, and was lost at the time in the political climate of that time. Colin James noted at the time that what we were seeing was a high watermark for treaty-based political justification of policy. And history shows he was right. Remember at the time we had somewhat silly advertisements from the Ministry of Social Development advertising for even junior positions, receptionists and like, that they needed to have an understanding of the principles of the Treaty of the Waitangi. And a lot of people in New Zealand just thought that it had gone too far. Okay. A lot of people thought it had gone too far. Now, that's not to deny the fundamental constitutional importance of the Treaty of Waitangi in our country, but there was a backlash against that. In any event, on one side we had Nationals saying the Foreshore and Seabed Act was too generous, and on the other side we had Tariana Turia and others saying it was too restricted. Some have asserted that the 2004 Act was rushed. I don't accept that. The Court of Appeal decision was on the 19th of June 2003. The Act, the Foreshore and Seabed Act, received royal assent on the 24th of November 2004, a year and a half later. There was a full select committee process, thousands of submissions, as Tariana Turia has acknowledged, public meetings and protest marches across the country. Some say the Crown ought to have appealed to the Privy Council at the time. I accept that that's arguable. It was complicated at the time. politically by replacement of the Privy Council by the Supreme Court. In my opinion, appeal would have been likely to overrule the Court of Appeal in finding that the Maori Land Court, a court of statutory jurisdiction, had jurisdiction over foreshore and seabed, given that nothing in the Empowering Act talks about anything other than land, and in fact land that is dry. And I personally was disappointed that the courts who have given themselves the power to have regard to Hansard in areas of ambiguity or uncertainty declined to do so in that case, because the Hansard debate doesn't show any reference. And I, for one, thought that that would have been overturned. But of course, while that may have been the case, legislation would have still been necessary to protect rights of public access, because the underlying thesis of the court was right, and that is that there were properly to be recognised unextinguished customary interests in the foreshore and seabed. That need for legislation to protect public rights of access and recreation was denied by the Maori Party until after the review panel concluded that it was necessary. It is now clear that legislation was also always necessary. We know that therefore appealing the decision wouldn't have cured things and that legislation was necessary. The 2004 Act was passed, and it's clear that criticisms from both ends of the spectrum were exaggerated. But it was not perfect, and Labor has engaged constructively to improve it. Changes to name, and it is mainly a change of name, from vesting the foreshore and seabed in the Crown to creating it as common marine and coastal area, don't change things in substance if the bundle of rights held by different groups are the same. And that's essentially what's happening here. The bundle of rights doesn't change. Public access is protected. It was never about fisheries and still isn't. Customary interests are still being recognised as they ought to be. The main difference between this legislation and the legislation that was passed under the Foreshore and Seabed Act is that Labor has agreed, and other parties agree it's appropriate also, that the court has the power to award a customary title, which under the current legislation is called a territorial customary right. We said that in our submission to the review panel, and this is an important change. I accept that. It has to be said it's an important process change. It doesn't change the substance of an outcome. It's an process change. Previously, a claim to a territorial customary right could be considered by the court. If the court found an unextinguished right remained prior to the Foreshore and Seabed Act, the court couldn't confer that right, but rather had to refer the matter back to the Crown for a negotiated settlement. And that carried with it a risk that a future government could frustrate fair claims, which is why we agree giving the power back to the court is appropriate, despite the fact that the prior regime did enable a fair outcome in respect of Ngāti Porou. Mr Chairman, it is clear that the changes being made could have been achieved by amending the existing Act rather than repeal, but we've said we can go along with that. It's important to the Maori Party, and so we will agree to that and as part of our offer to get this settled. We've heard a very Greaser was the comment that we had from Tauhenere. Well, that's just sort of Tauhenere. That's the sort of unhelpful, the same sort of unhelpful rhetoric that we don't need to settle this dispute. Mr. Speaker, legitimate issues have been raised over whether the new legislation will settle the protracted controversy. The stated objective of the government, which includes both National Party and Maori Party members, is to fairly settle the issue. And it's perfectly reasonable to expect that John Key, on behalf of National, will obtain an acknowledgement for the Maori Party, or that the Maori Party will offer it that the proposed legislation fairly settles the framework for foreshore and seabed claims. Failure to achieve this will represent a failure by both the Maori Party and the National Party in their duties to the country to reach a fair and enduring outcome. Labor has given them a benign political environment in which to do this. We haven't scaremongered. We didn't run Kiwi, not iwi billboard campaigns like National ran when this was first. And in fact, we have been public in our criticisms of those who are running a billboard campaign against National at the moment. Ironic though we see that, we have actually done the right thing and criticised that as being wrong. We agree that achieving full and final settlement of the legal framework for foreshore and seabed is important for our country. And if it's not going to be achieved in the benign political climate that we have helped create around this, then when will it ever be created? And if we as a country can't deal with these issues and move forward in a fair and durable way, then it doesn't say a very good thing about our country. Mr. Speaker, if the acknowledgement that this new legislation settles the framework fully and finally is not forthcoming, then I believe that the Maori Party will have failed their duty to the country